manufactured home counter proposal and a manufactured home amend extend. So um, before we actually dive into the contract, we'll look at a little piece that Dora put out. But before that, really, there have been different terms used for different things in different industries. And so there's a lot of confusion with respect to what is a manufactured home. How does that compare to a mobile home? How does that compare to a modular home, right? And so, we have to kind of forget anything that you think you know about manufactured and modular homes. I just want you to kind of put it out of your mind for the purposes of this class and for the purposes of determining which contract you're supposed to use and what you may or may not be allowed to partake in. So, having said all of that, the important thing to know is that, your real estate license allows you to participate in transactions where there is a real property component. Right? And typically, forget about the term manufactured home. Let's talk about mobile home as you and I might maybe, understand a mobile home to be, right? Typically, a mobile home is not considered real property, okay? And so if I were just selling a mobile home and there was no real property component, well, then that's not covered by real estate license law. That's covered by the Division of Housing, which sounds a lot like the Division of Real Estate, but it's not. It's a completely different governing entity under the Division of Regulatory Agencies in Colorado. And they're the ones who are responsible for dealing with, what you and I might think of as a mobile home or a manufactured home with no real property component. Okay. Now, what is a real property component? Well, it could be that you have what, you and I might even call a mobile home, right? If there's a mobile home that is being sold in conjunction with a piece of land, right? Well, selling that piece of land, the land is real property. Therefore, there's a real property component. Therefore, that's a transaction that you would be able to partake in as a licensed real estate broker in the state of Colorado. Okay. Now, the other piece that's important to know is you may have what you and I might know as a mobile home, right? And let's say that it's in a mobile home park, right? If it's in a mobile home park, typically there is a lot lease that is associated with the sale of the mobile home itself. So that lot lease, because there is a lease involving real property, the lot is real property, and there's a lease involved, there is a real property component to that, and therefore that is the transaction in which you can partake. Okay. Where you might run into restrictions is where, let's say that, I own 40 acres of land and I've got a home, a built home on my 40 acres, right? And then there's also a mobile home that, is on my property. And I just want to take that mobile home and sell it to someone else who is going to move it off of the property, right? Well, in that case, there's no real property component. Okay, the only thing that I'm doing is selling the mobile home, and the mobile home is personal property. It is not real property. Okay, and so that would be a transaction that would be prohibited under license law. Okay, does that make sense to everybody? Just to clear things up before we get started, there has to be a real property component, which could be a piece of land that's in conjunction with the sale of a mobile or a manufactured home, or a lot lease that's in conjunction with the sale of a mobile or manufactured home. Okay, those would both work. What doesn't work is the sale of just a mobile home, right? Where there is no land that's being sold with it. There is no lot lease that is a piece of that transaction. That would be excluded. Okay. Now, digging into some of the weeds here, right? That if you were to actually go read the statutes, what the statutes say is that you have to be involved in the negotiation of that real property piece, right? And so a lot of people go, well, I'm not really going to be involved with the negotiation of a lot lease in a trailer park or a mobile home park, manufactured home park, whatever you want to call it, right? And so that being said, forget about what you think it means to negotiate, right? For the purposes of the statute, negotiating the terms of that lot lease is effectively just, hey, I'm gathering the documentation, I'm passing it on to my client. I might be advising them with respect to the terms of that lot lease. Maybe there is some actual negotiation, but there probably is not any negotiation as you or I think of it. Okay. But we are involved in that process. We are helping our clients with that process. For the purposes of the statute, that satisfies the negotiation of the real property component. Okay. So it doesn't mean that you have to go beat up the manufactured home park or the mobile home park manager and try to get their lot rent decreased. That's not what negotiation is for the purposes of the statute. Okay. So let me pull up a screen here. We're going to look at just kind of an advisory which came from DORA. And DORA is a division of or Department of Regulatory Agencies. The Colorado Division of Real Estate is one of the divisions in the Department of Regulatory Agencies. And guys, mute yourself. I'm getting some music or something from somebody here. So do me a favor, everybody, mute yourself. There we go. Again, the Real Estate Commission falls under the Department of Regulatory Agencies, and so does the Division of Housing. And the Division of Housing is what would govern that type of transaction where there is no real property component that we just talked about. Okay, and so what happened was Division of Real Estate, Division of Housing, DORA, they kind of came together as one body, and they said, hey, we need some clarification as to what real estate brokers are and are not allowed to do. And in conjunction with all of that, DORA and the Division of Real Estate effectively put out this, call it an article, call it an advisory, whatever. And it just gives you some things to think about, okay? And so we will go over the forms themselves and we'll talk about the differences, but let's start here. So normally the sale of the manufactured home requires that a seller or a person selling on behalf of that seller has to be registered as a dealer with the Colorado Division of Housing. Okay. And again, this is different than the Division of Real Estate, which governs us as real estate brokers. We are not, as real estate brokers, licensed or registered as a dealer with the Colorado Division of Housing. That's completely different. And so just to give some examples of who would be required to register as a dealer with the Colorado Division of Housing, a seller who, if they own the land that they are selling or leasing with a manufactured home that they are selling, then they would be required to register as a dealer with the Colorado Division of Housing. Another example would be a manufactured home park, what you and I might call a mobile home park or a trailer park, right? The owner must be registered if they are selling a home, a manufactured home or a mobile home on one of the lots that they are leasing. Well, then they have to be registered as a dealer with the Colorado Division of Housing, okay? Now, that being said, there is a carve out inside this law for real estate brokers, okay? And so that's the exemption. So we are exempt from these requirements as long as we meet the terms of this exemption. And so we'll go through this real quick. So there's a real estate broker exemption that allows us to sell manufactured homes. However, it only applies when there is land involved with the sale of the manufactured home and they do not own the land. Okay, so this would be sales where a lot lease is involved, like mobile home park type of thing. If the broker is negotiating the terms of the lease, and again, forget about negotiating the price. That is not what it means. It just means, are you advising your client? Are you a part of this, lot lease? Do you have it in your file? And the answer is yes, you should if you're partaking in this transaction. So forget about that term negotiating. It just, are you a part of this land lease with the mobile home park or manufactured home park? Okay. Or the other part of the exemption is the sale of the manufactured home is in conjunction with the sale of the land itself. So that's that real property component, is either the sale of the land or the leasing of the lot, okay? So in those instances, the person is required to be a licensed real estate broker, which we are, and therefore we would fall under that real estate broker exemption. Okay. There's another memorandum, which we're not going to go back and look at. A lot of that stuff is covered here as well. And so, the Division of Regulatory Agencies, DORA, and the Real Estate Commission, they want to point out that there are some risks associated with these particular transactions. And so, the first piece there is that the contract provisions in the sale of a manufactured home, at least some of the terms, not all of them, much of it is going to look very similar to you, but some of those terms are substantially different than what you know in the contract to buy and sell. And so, it's important for us to be competent, right? That's the big thing with the Real Estate Commission right now is, are you competent to partake in whatever transactions you are partaking in? Okay, and so if you don't understand the terms of the contract and how they differ compared to what you know as the contract to buy and sell, well, then you're probably not competent, and therefore the Real Estate Commission could take action against your license. So you must be competent to partake in these. And part of that is understanding the difference in the terms. Okay. It's important to know when and how to use the different forms. And so we'll talk about 4 forms today. We'll get to those. You have to be familiar with the UCC and the financing statement searches that are associated with it. And so what the UCC is, if you think about a typical real property transaction that you might be involved in, right? The sale of a stick-built house, let's say. If a person takes out a mortgage, or really Colorado is what's called a deed of trust state, right? But deed of trust, mortgage, for the purposes of this conversation, we're just going to use the same, right? And so if somebody has a mortgage against their property, that mortgage gets recorded in the public record. Right? And that public record is something that you can go and you can search and you can find, okay, there is a mortgage that's associated with this particular property, and therefore it needs to be paid off at closing when the seller goes to sell. Okay, so similar, but a completely different area that gets searched for personal property. So if there's a lien that gets taken out against a property, let's call it a mortgage, right? That is a personal property as opposed to a real property. So if someone were to get a mortgage on a mobile or a manufactured home that is not part of the real property, then that gets recorded in the UCC. It does not get recorded in public record. And the reason that that's important is if you have a title company that is performing the closing and they don't know that they need to go look in the UCC to go verify whether or not there's any liens or encumbrances or mortgages against this property, right? And they just close the deal without going to do that search, what could feasibly happen is your buyer may purchase this personal property, let's say $50,000, right? They may go purchase this $50,000 mobile home and they pay $50,000 cash to the seller, right? And then the seller never takes that $50,000 to go pay off the $40,000 that they borrowed. And then the seller disappears. So now your client has, they've paid $50,000 to the seller and they still have a $40,000 debt against their property. Okay. So it's important that you know and understand what the UCC is, that you're familiar with those searches, or if title is going to be doing it, that title is familiar with those searches. It's important that we know to advise our buyers in particular that they need to make sure that they're researching the UCC, making sure that there are no liens and encumbrances against the property, which is different than public records with real property that's found in the UCC.
And Jesse,
yep.
The UCC, isn't that what came up in our commission update? I think it was like last year when we were talking about the personal property bill of sale and making sure that all that was clear.
Yeah, so there is a personal property agreement that's a form that came out a couple of years ago. And yeah, part of the problem with that was that people were including personal property, forget about mobile or modular manufactured homes, right? Let's say like a tractor. Well, if somebody was including a tractor in that personal property agreement, right? It's important to know whether or not there's any liens or loans that have been taken out where that is collateral, right? And so those get recorded in the UCC. Those do not get recorded in public records like mortgages do. Yeah, so yes, to answer your question, that's exactly where liens against those personal property items would be, is in the UCC.
What's that acronym mean, Jesse?
Uniform Commercial Code, I believe. So don't ask me how they came up with it, but that's where those liens and encumbrances against personal property get filed. Okay. There's competency concerns. If you've never handled this type of transaction, they're not the same as a typical buy-sell transaction of real property. And so if you're not competent to take those on, if you've never done them before, the Real Estate Commission says there's several ways that you can get, that you can become competent, right? You can, be advised by somebody who has experience in those type of transactions. You can partner with them. You can refer the deal out to them and still, have them kind of mentor you on those things. You can take classes. There's different ways that you can become competent, but just dive in, having never done one before and not really understanding what you're doing, that creates competency issues. And again, the Real Estate Commission can take action against your license as a real estate broker. Okay. There's differences and complexities with the transfer of title to the buyer. So with a real property, let's say a still-built house, right? It's built on a lot. The property is transferred via a deed. So we have general warranty, special warranty, right? Various different types of deeds. However, with personal property, it is typically transferred via, a variation of different things. Could be a bill of sale. Mobile and manufactured homes are typically transferred with what's called a certificate of title. Okay, and so there is no warranty deed, general warranty deed. It's a certificate of title. And then there's some other documents that need to be filled out in conjunction with the transfer of title. So after closing, for instance, the buyer needs to take some forms to the county and register it with the county so that the buyer will get a new certificate of title as the new owner. Okay, and part of doing that is they have to have this verification that they've paid ad valorem taxes. Well, ad valorem taxes are similar to what you might pay, property taxes on real property, right? Ad valorem taxes are just taxes based on the value of personal property. Okay, so there's some complexities that are just different with respect to the transfer of title as opposed to the transfer of the deed, which typically would happen at closing, right? There can be difficulty finding an entity that will actually close a manufactured home transaction. So you might go to your favorite title company and say, hey, here you go, here's this contract. And they say, hey, I'm really sorry, but I can't close that transaction. It's not in our company policy. We're not going to do it, right? Well, now you have a contract that says so-and-so is going to be your title company who's going to hold the earnest money and do all these other things. And now they're refusing to participate in that transaction. So if you're going to participate in these, you need to go talk to your title representatives and figure out, hey, if I do have a manufactured home, are you able to close that transaction? Are you comfortable and understand the UCC? How do you handle the certificate of title and transferring that to the buyer, right? Have that discussion before, right? So that you and your client are not the guinea pigs. That is where the competency concerns come from, okay? Does your broker cover these types of transactions as far as their E&O policy? Yes, our E&O policy covers, again, the transactions involving a real property that have a real property component. So if you decide that you're going to go sell a manufactured home that doesn't have a lot lease, it's not in a mobile home park, right? And it doesn't have real property that's being sold with it, then no, our E&O insurance doesn't cover you on those transactions, okay? So it's advised before you represent a client of the manufactured home to go familiarize yourself, take classes, whatever. Guys, I don't pretend to be the authority on manufactured homes. I have never even sold a manufactured home. I know certainly enough to be dangerous, and I've taken Damien's class on selling manufactured homes. I am not the authority, but certainly this is a piece of the competency, becoming familiar with which forms you're supposed to use in which transactions, which types of transactions are covered by real estate license law, which ones are not, right? So I don't pretend to know all of the nuances and complexities. Certainly I know enough to be dangerous, and I can point you in the right direction. But that being said, if you've never had any class, if you don't even know what contract to use, I'm not going to be your go-to and just, mentor you on a manufactured home transaction. Okay. There's some additional resources here, which we're not really going to look at, but they do have some good information. After class, what I'll do is I will put together a list, with these links, right, and the contracts and whatnot, so that if it's something that you are interested in and you've got a deal that you're doing, you can go look and you can figure out, what this brochure says, the flow charts, all these other things. You can go play around in the UCC, do some searches, whatever. Okay, so I'll put together some links and we'll blast that out after class. But for now, do you guys have any questions with respect to what types of transactions are and are not allowed under real estate license law? Is that unclear to anybody what we can and can't do? So Julie chatted in, and Julie, just so you know, I think you hopped on a little bit late. I'm not going to be checking chat super regularly. I just happened to see it. So as unmute yourself, I'd rather talk to you as a person. But Julie said, so if there is a lot lease on the property, that's the real property component, yes. And even though the buyer wouldn't be purchasing the real property because it's a lot lease, it would be covered under E&O. Yes is the answer to that question. Okay. So let me close.
I didn't want to interrupt you earlier. Okay. There's a really good example of this going on right now in Granby. Okay. There's a resort style community that's being built by Sun Properties called River Run. And they are all manufactured homes, really cute, really pretty, great views, but they're not technically on foundation, they're on pillars, and they are also on a lot lease.
So this is a little bit of a curveball, which I wasn't really going to go into, but there are some places, there is an exception, right? There is this carve out that says if it's on a lot lease of longer than 10 years, then it may be applicable for us to partake in that as well, right? Because it's a long-term lease where, even though you're not renegotiating the terms of a lease, you're really only partaking in the sale of that home itself because it's subject to a 10-year lease that's already in place. Because it's a 10-year or more lease, then it becomes it effectively gets shifted into this real property component. So I don't know how long those lot leases are, but there is a place in Fort Collins, right up off of Mulberry. So it's called the Sunflower Community. So it sounds like maybe even the same, I don't know, same owner or type of thing. And in that case, it is actually, even though it's not on a permanent foundation, it is considered real property. And therefore, we don't even use the manufactured homes contract for that piece. Okay. So, just again, a little curveball is let's talk about purged, what it means for the records to be purged. Okay. Because this might help you. So, purging is effectively the process by, if we think of let's say a mobile home, what you and I know as a mobile home, typically that comes with a certificate of title, right? It does not come with a deed. And that certificate of title is administered by like the DMV, I think, right? And so what purging refers to is affixing that let's call it a manufactured home, affixing that manufactured home to real property. And once you affix it to real property, then you purge those records from effectively the DMV and get a deed to the property, because now it has become a permanent fixture on the real property itself. Okay. So if a property has been purged, it is real property. Okay. And if it's real property, we just use the standard contract to buy and sell. So if we're talking about a purged deal, we don't even need to delve into the manufactured homes contract. Okay.
Okay, yep, got it.
The other piece that can get a little bit weird is that technically purging means, that purging, what I just gave you is like the common, that's what most of us refer to when we talk about purging. However, the legal definition means that manufactured home can no longer be drawn across the public roadway, basically. And so that's why there's there's this 10-year, this is like closing the loop with the 10-year lease, right? We're saying, hey, for a period of at least 10 years, this home is not moving, right? And so even though we may not be removing all of the pieces that would allow it to be pulled across the public roadways, right? Because there is that 10-year or more lease in place, it effectively becomes real property. It effectively becomes like a purged home would. And therefore, we can just use a contract to buy and sell, and those properties typically receive deeds. And so if you're not sure, right, if a property is transferred via a deed as opposed to a certificate of title, then we're just going to use the standard contract to buy and sell. We're not even going to use the manufactured home contract, right? The manufactured home contract is really for properties that are titled properties, meaning they are transferred via a certificate of title as opposed to a deed, which is how we transfer real property. Okay.
Yep, that makes sense. Thank you.
Okay, cool.
So, Jesse.
Yep.
So you buy this manufactured home and it's on a lot that's owned by somebody else. Does the person who has the land have to then lease that land to you because that home was on there and you were purchasing it based on staying there, or do they not?
Well, I mean, that's all stuff that has to get hammered out up front, right? I could be the owner of 40 acres and just have a mobile home on my property that I just want to get rid of with the intention that it's going to be taken off my property, and you go take it somewhere else, whether you go park it in a mobile home park or you go buy some other 40 acres and park it on that 40 acres, right? I don't know. It's all stuff that has to get hammered out up front. And in some cases, the intent is that mobile or manufactured home is going to leave my property, right? And in that case, there is no real property component because I'm not selling you my land and I'm not leasing you my property. Now, certainly there could be an agreement that, there might be a lot lease, but, in most cases, the lot lease is truly going to be like a manufactured home or mobile home park, right? It's not going to be, hey, I'm selling you this mobile home that sits on my back 40, right? And I'm going to not only sell you the home, I'm also going to make you pay a particular amount of, rent per month, right? We're more concerned with the lot rent, and the lot is specifically defined in the contract, the manufactured home contract. So it really just depends on the situation, but either could apply. Okay.
Do you have any recommendations as far as title companies that are very familiar with this?
So I have heard that Stewart Title will do them. Again, I don't sell manufactured homes, not because I haven't had an opportunity to. It's just I don't. And so just to kind of go back and I guess add one other piece of an advisory to you that DORA advisory didn't really mention is that these are high risk, low reward transactions in most cases in and of themselves, right? I mean, typically we're talking about $40,000, $50,000 manufactured home. And, if you're making, 3% on that, right, you're talking $1,500 by the time you pay your office splits and everything else, right? You might be walking away with less than $1,000 on a manufactured home transaction. And if there was some kind of E&O complaint, right, if it's covered by E&O, you still have a $2,500 deductible under our E&O policy. And so your total commission that you're going to make is less than your E&O deductible if something were to happen, And so you're engaging in a higher risk transaction with a lower reward than maybe a typical stick-built home would be. Now, the argument there, though, that people say, well, it's worth it to me to do it. One, it pays, I'd rather have $1,000 than zero in some cases, right? Now, for me, right, I have other things. I've been doing this for 13 years. I have other things that I would rather focus on. And so I just choose not to do those. The other piece, even for an experienced broker who has enough business to keep them busy all day, right, is that, if somebody is like, hey, I'm going to sell my manufactured home, and in return, I'm then going to go buy a stick-built house, right? Well, now you might be making $10,000 on that thing. And so is it worth diving into, taking on a little bit riskier transaction for less reward? There's the promise of another deal on the other side. To me, yes, that would at least make a little bit more sense. And I'm not telling you not to go sell manufactured homes. I'm just saying you have to weigh the pros and cons. And eventually you may get to a point where you say, hey, it's just not worth it for me at this point in my career. And so, you have to weigh where you're at. Everybody, you guys are all, you're big kids. You can decide what's best for you and what's not best for you. And if putting $1,000 on the table is worth it for you, then yeah, absolutely, by all means. I'm not knocking manufactured home transactions. You just have to figure out, is it worth it for you or is it not?
Okay. And just in the Longmont area, Jesse, for anybody that's interested, Doug Priest has been a resource for me as of recent because he sold one over here.
Yep.
Through the trials and tribulations, and he's open to masterminding about it, and he's actually about trying to gather some people if there's people interested.
Yeah, and I know there's some stuff, particularly off of 119 there. I think there's a fairly large manufactured home community there. And they pop up everywhere. So if you guys have questions, seek out those people who are resources, who have done these things before. But maybe more importantly is that now we have some specific guidance as to what we really cannot do. And again, that what we can't do is we can't just sell a manufactured home that is considered personal property because it has not been purged, right? When there is no real property component. The part that I'm talking about off of 119 in Longmont, there is a real property component because there is a lot lease. So those are certainly transactions that you would be allowed to participate in. But just know the differences between what we can do and what we can't do. And then the next piece, which we're going to dive into, and if there's more questions, that's fine too. But what we'll dive into next is, okay, now that we know what we're allowed to do and what we're not allowed to do we use the manufactured home contract? Do we use a different contract with the manufactured home addendum? And then we'll talk about the counter and the amend extend. So any questions before we dive into contract stuff?
I do have one question here. Can you hear me okay?
Yep.
This is Jeffrey. Yeah. So just to be clear on the 10-year carve out. So regardless of whether it's 10 years or 4 years, the duration, we can participate in the transaction. And the 10-year carve out, that won't really dictate whether or not we use an official contract to buy and sell or a manufactured home. What really will dictate that is whether it's been purged officially, correct?
So really the easiest way to figure out which contract am I going to use is, well, when you're trying to determine, do I use the standard contract to buy and sell that we've always used, or do I need to look at using the manufactured home contract or a different contract with the manufactured home addendum, right? The easiest way to determine that is this property transferred via deed, or is this property transferred via certificate of title? And so again, the 10-year thing, it just adds a little bit of an extra wrinkle because you have a property that may not officially be purged, right? In the sense that it hasn't been connected to the, permanently connected to the real property, and that the records still exist within the DMV. But because there's that 10-year lot lease, they've effectively said, no, we're going to transfer these via a deed as opposed to a certificate of title. So in those cases, we're going to continue to use the regular contract to buy and sell that we've always been using, even though the property may not necessarily be connected permanently attached to the real property. So again, that was a little wrinkle I wasn't going to get into, but because Julie brought it up, there are these communities that exist where there are these long-term lot leases in place. And so Sunflower, I think the lease is like a 25-year lot lease or something like that. And so those ones are transferred via a deed, and we just continue to use the contract to buy and sell on those. But if we're talking about a normal mobile or manufactured home community, we would actually be using the manufactured home contract. So that I know this is like a weird new thing, and trying to understand all the nuances can get a little tough. Like I said, I'll put together a list of resources, but that's going to be the easiest way to determine which contract am I using is to start with, is it a deeded property or is it a titled property?
Appreciate that.
So let's talk about the actual contracts here. Give me a second while I pull it up. So what we're going to do is we're going to start with the actual manufactured homes contract, so there's a manufactured home contract to buy and sell, and then there's what's called a manufactured home contract addendum, and that addendum would be used in conjunction with either the land contract or the commercial contract. So you would actually you wouldn't use the residential contract if we're talking about a titled home as opposed to a deeded home. Right? We either have to determine, do I need to use the manufactured home contract, or I need to use the addendum in conjunction with the land contract or the commercial contract. Okay. Now, the way that you can determine that is on the manufactured home contract, it tells you in parentheses here, this is for the lot lease only, type of transaction, where we are not dealing with the sale of land. We are dealing with a manufactured home that is on a leased lot. Okay, so for all intents and purposes, I want you to think mobile home park or manufactured home park, right? That is when we would use this contract. Okay, so we're going to start here because this is by far the lengthiest contract between this and the addendum and the counter and the amend extend. So we're going to start here because a lot of this will flow into those other documents. Okay. So that being said, if you guys have questions, just stop me. I am not going to go over every single thing. We will talk about kind of the differences between this contract to buy and sell versus a standard residential contract to buy and sell, and why these things were done the way that they were done. Okay. So if you determine, again, think mobile home park, manufactured home park, where we are selling a manufactured home that is on a leased lot where we are going to negotiate, right? And again, I use that term loosely. We're going to negotiate the lot lease, right? That is the real property component. And there is no sale of the land involved. Okay, that is when we use this form. And so just like all of our other ones, the first section is it defines what the agreement is. It defines contract. Okay, but rather than use the term property with a capital P, you'll see that there is nothing that says property in here. What it says is home with a capital H. Okay. And it makes sense. The reason that they do that is there is no property that's being sold, right? This is a contract to buy and sell. This has nothing to do with the lease, the lot lease itself. The lot lease itself is a completely different document, right? So we can't have something in our contract to buy and sell that says the buyer is going to agree to buy and the seller agrees to sell the property. That would be a different contract to buy and sell that we would use if that were the case. So in this case, we're just saying home with a capital H, which will be defined down here. Okay. The buyer is going to agree to buy and seller agrees to sell the home described below, subject to all of the terms and conditions that we're going to lay out in this contract. Okay. Buyer, just like contract to buy and sell. Are they going to take title as joint tenants, tenants in common? If it is an LLC or an individual, you might check the other box and you would put in severalty, right? But in most cases, probably joint tenants if you have multiple people purchasing. Every now and then you'll run across a tenants in common situation. Fairly often you'll run across an individual or an LLC or whatever, and that would be in several. Okay. 2.2 is the same. Contract is not assignable unless the buyer and seller agree otherwise. Okay. Seller's names, again, name or names, put them both in the blank there. That's similar. And the seller's is the current owner of that home with a capital H that we are going to define down here. Okay. 2.4 looks different than what we, are normally used to. 2.4 talks about the home and the lot, and not the property. It talks about the lot. So the home is the manufactured home located on the lot described below down here, right? That is further described as, and then we have all of these descriptive features of the actual manufactured home. And so the more of these things that you can fill out, the better. Who is the manufacturer? What was the model? What is the serial number? How big is it? Right? And manufactured homes are not always described in the same terms that we use, right? I mean, they may be. Some people refer to manufactured homes as a, 14 by 48, 14 feet wide by 48 feet long, right? Or some people may just refer to the total size. So, it may not hurt to put both of those in there. What is the width by the length, right? And what is the total square feet? Put those both in there. I think it just helps. Okay. How old is it? What's the certificate number, manufacturer tab number, VIN number, whatever information you have and you are able to, fill out here. It's just more confirmation that, hey, I'm actually selling you this particular unit, that we don't get confused that, hey, I thought that it was the unit next door, right? So fill out as much of that stuff as you can. Most manufactured homes will have either like a HUD tag on it. A HUD tag looks like a little metal license plate kind of thing. And then they also have what are called data plates inside. And those data plates are typically posted, like if you open the cabinets underneath the kitchen sink, there's like a big sticker, basically a piece of paper that's like stuck to the inside of that cabinet. Sometimes it's in the master closet. Sometimes it's like inside the closet that has the furnace in it. And sometimes they've been removed, right? You have 4 kids like I do, and your kids are like, oh, look, a giant sticker. I'm going to go tear it off and, put it somewhere else and whatever, right? So sometimes those things are hard to find, but be as descriptive as possible so that there's no confusion as to what you are selling, right, as far as the home itself, okay? So the home is going to be sold. The lot, the home is located on the below lot, and you'll put whatever county it's in, right? And you'll put the space number. So it's in space number 192 of Cloverleaf Community, whatever, right? So name the mobile home park or manufactured home park, okay? And then that way it's clear, okay, I'm purchasing this particular manufactured home. This is where it's located, right? And this is the lease that I'm going to be negotiating in association with the lot, okay? And then if it has a known as street address other than like number 192, whatever the street address is, we'll put that there, just like in the contract to buy and sell, okay? The inclusions, so this is fairly similar for the attached inclusions, right? So, these items are included because they are attached to the property, unless for whatever reason the seller specifically wants to exclude them, in which case they would be listed under exclusions. Again, this is all similar: lighting, heating, plumbing, HVAC, TV antennas, cables, wirings, mirrors, floor coverings, intercoms, right? All these other things. And so you don't need to go write those into the inclusions. If they're listed here, they're automatically assumed to be included, okay? And then if the following are owned by the seller and included, then you would check these boxes. If they are leased, you do not check these boxes. You would put them down in section 2.5.5. So if you happen to have a manufactured home that had solar panels on it, you got to go figure out, okay, are these owned or are they leased? If they're owned, you would check the box. If they are leased, then you would list them down in 2.5.5. water softener systems, security systems, satellites, whatever. Okay, all of that stuff is similar to the contract to buy and sell. And then if any additional items get attached to the home after the date of the contract, then those items are also included in the purchase price. Okay. Now here's where it gets a little bit different. In 2.5.2, it says if the following are located on the lot on the date of the contract, then they will be included unless they're listed under those exclusions as well. And so this is where we have some new stuff that is not in the contract to buy and sell. So the skirting, right? That's the trim piece basically that goes around the bottom of those manufactured or mobile homes. So skirting, the wheels, what makes it a mobile home or manufactured home, right? The tongue, all of the access equipment such as the ramps going up to the front steps, the deck, the stairs, all of those things, right, are things that would be included that are not listed in our standard contract to buy and sell. And then from there, most of the rest of this stuff is all the same as what we're used to: storm windows, storm doors, window and porch shades, awnings, blinds, screens, yada, yada, yada. All of those things. I'll get on my soapbox here and tell you storage sheds are already listed as an inclusion. You do not need to go down and write that the storage shed will be included in the storage facility section. Storage sheds are already listed there. Okay. But all those other things are similar to the contract to buy and sell. Yeah.
So on the storage sheds, some parks have their own storage sheds, and some people have, in addition to or even minus, they have their own sheds. So
yep. Yeah. So if that's the case, if it's not owned by the seller, then probably I would list it as an exclusion.
Right.
There's no confusion as to, hey, I don't own it, right? Or you could go down and you could put that in the storage facilities piece, right? And say that it is included. However, right, the storage shed itself is owned by the park. It is not owned by the seller. Okay? So because per the contract, it is standard conveyed with the property.
Right, but not.
So you got to be aware of that. And again, this is where the nuances with mobile or manufactured home parks comes in, is what do you know and what don't you know? You thought that it may have been included, but it may be owned by the park. Okay. Same thing with like garages and other things associated with the mobile home parks, right? In some cases, they own things that you might assume belong to the property itself. Okay. So per 2.5.2, right? All of those things are standard inclusions unless they're listed as an exclusion. 2.5.3 just says, those inclusions that we've mentioned here, along with anything that we've mentioned here, are going to be conveyed at closing by the seller, free and clear of any taxes, liens, encumbrances, all that other stuff. Right? And then accept whatever, right? In most cases, you're just going to put none. I want it to be conveyed free and clear of all liens and encumbrances. However, if there was going to be something that transferred to the buyer, right, then you would list that here. So, if you have payments that you're making on whatever, your storage shed that's out in your yard, then maybe that gets conveyed, right? I don't know. So in most cases, you're just going to put none here. Okay. Conveyance of all those inclusions will just be by typical bill of sale or other applicable legal instrument, right? The property, I shouldn't say property. The home itself will typically be transferred via certificate of title. However, you will still typically have a bill of sale or any of those other items that are listed as inclusions. Okay. Other inclusions, so this is where you would write, the fridge, the washer, the dryer, the stove, oven, disposal, right? Whatever other items are going to be included, similar to the contract to buy and sell, that's where you would put those items. Okay. 2.5.2, we kind of already talked about. Those are those leased items. So the solar panels, the water softener system, security systems, any of that type of stuff would be listed here. Okay. Exclusions, again, guys, we don't need to put personal property in there. The standard contract to buy and sell is for real property, right? We don't need anyone's permission to take our personal property. And so if you specifically in this contract say that the following items are excluded, the seller's personal property, well, the manufactured home itself is personal property,
Mhm.
okay? So if you put the seller's personal property is going to be excluded in a
Lovely.
contract where you are purchasing the seller's personal property, then you've got conflicting information in
You're
the
wasting
contract that
my
could
time.
create trouble, okay? So be careful about putting that in there. Some listing brokers just don't understand that concept, right? And so if you have to put it in there, maybe put like the seller's personal belongings. But even then, you don't need it. That is not what our contract is for. I don't need permission to take my underwear, right? It's going with me whether you like it or not. Okay?
Better example.
Trust me, you wouldn't like it. So, okay, you don't need to list seller's personal property there. Okay. 2.7 is all new. So the lot in 2.7 is where we talk about the lot lease. So the seller is a tenant under a lease for that lot, and that's defined as the lot lease. Okay. So the seller is going to agree to deliver a copy of that lot lease to the buyer on or before the lease delivery deadline. Okay. So you'll see that that's one of our dates and deadlines that is in our dates and deadlines table that was not in the standard contract to buy and sell. Okay. So seller's going to deliver that lot lease to the buyer on or before the lease delivery deadline. There's also typically a lot owner approval because in many cases in a mobile home park, there are several things that actually have to get approved. So for one, the buyer typically has to go through a background check. Okay. Two, some mobile home or manufactured home parks have requirements with respect to the type of home that they will allow in their community. So they might say, hey, I don't take anything that's older than 1990. So if you thought you were going to go in and bring your 1978 manufactured home and park it on a lot in there, and then that was a piece of your contract, right, was me being able to, sell you this 1978 mobile home or manufactured home, and then you're going to be able to put it on this lot. Well, no, that doesn't work because this park may have certain requirements that say, no, you can't do that. Okay. So whether that lot owner approval is contingent on the buyer getting approved, the home getting approved in writing, or an assignment of the lease to the buyer, right? Those are all things that we have to deal with now that we didn't have to maybe deal with in the contract to buy and sell. Okay. It's conditional upon all of those things being approved on or before the lot owner approval deadline. Okay. Now, 2.7.3 talks about the lot owner approval fee and who is going to pay for that. Is it going to be the buyer, the seller, half and half, or none? And what they really need is they need a box here that says other, because feasibly, it could be paid for by the agent, it could be paid for by a third party, right? But for whatever reason, we went with buyer and seller, half and half. Keep in mind, guys, this is like the first version of this contract. And so there's actually some typos in here as well. You'll see it says receiving, right? There's no G on there. So there's things that need to be changed at some point in the future. They'll correct those. And then they'll add probably a box that says others. So there's some suggestions that have already been made. But this is what we're stuck with right now. Or you can go down to additional provisions if it's going to be someone other than the buyer or seller, half and half, right? You could say in regards to 2.7.3, buyer's agent's going to pay the lot owner approval fee or whatever. Okay. Which don't do that because you're already not making a lot of commissions. So I don't recommend doing that, but it should be an option to have other. Okay. All of those things are conditional on the buyer's review. So the buyer obviously needs to have the right to review the lot lease, make sure that, hey, you said it was $600 a month lot rent. I need something in writing to show that that's actually the case, because if I buy this and it turns out it's $900 a month, well, that might be more than I can afford, right? So buyer needs to have a right to review those things, need to have the right to review that lot owner approval. They can terminate under 2.1 on or before the lease review termination deadline if there's anything in there that's unsatisfactory in the lot lease or the lot owner approval in the buyer's subjective discretion. Okay. Now, if the buyer receives either the lot lease or the lot owner approval after the respective deadline, then the buyer has the right to terminate, under section 22.1 by delivering a notice to terminate to the seller on or before 10 days after the buyer's receipt. So if those documents do not get delivered by the respective deadline and they get delivered afterward, effectively what that means is now the buyer has 10 days or up until closing, whichever is earlier, right, to terminate the contract. So if you're working with the seller, it's important for you to know when those deadlines are and can I hit those deadlines or can I not? Because if I don't, and then I deliver those to the buyer later, I've effectively opened up a free 10-day period for the buyer to terminate if there's something in there in their sole subjective discretion that they object to. Okay. Assuming those documents are delivered on time, if the seller doesn't receive the buyer's notice to terminate within whatever the specified deadlines are, then the buyer accepts that lot lease and they accept the lot owner approval as satisfactory, and they lose their right to terminate under this provision. Okay. So any questions so far?
What does a mobile home lot lease typically look like as far as the terms and duration?
Totally depends on the park, and I wish I could tell you there was a standard form, but there's not. They all, every park has probably an attorney, I would hope, drafting what that lot lease looks like, and attorney drafted forms are just not standard forms, and so there is no standard thing that we can go over and we can review. I mean, we can certainly look at examples, but they're all going to be entirely different and just totally dependent on the park.
Is the duration? I'm sorry to interrupt, but is the duration typically for a year or month to month?
Again, it could be totally different depending on the park. I mean, I'll tell you, in most cases, if it's a mobile home park, right, most of them right now, kind of the going lot rent seems to be that $600 to $700 a month. Now, there might be some lots where you have, a significantly larger lot or better views or a better location in the community, right? And I've seen stuff that's over like $900 a month just for the lot rent, right? So, and then I've also seen some that are like $300 a month. So, the price is a little bit more easy to tell you what it is as far as the lot rent. And again, I would shoot for $600 to $700 on most parks, and for you guys that do a significant number of manufactured homes, have you guys seen stuff kind of outside that range? Anybody seen higher, lower? I mean, that seems to be kind of the middle ground, is at $600 to $700 a month, right? But as far as the duration, I mean, most parks, probably the initial lease is probably going to be for at least a year, because they probably don't want people, who are super transient coming and moving in and out and everything else. But certainly there are some that could be longer, and there might be some that might do month-to-month leases, totally just dependent on the park. Okay, let's look at our dates and deadlines. So some of these are identical to contract to buy and sell, and some of these are all new. Okay, so alternative earnest money deadline, if you're not going to deliver the earnest money with the contract or with the offer, right, then you need to have the alternative earnest money deadline. That is no different than anything else. Okay, these are all new: the UCC and title deadline, UCC and title objection deadline, UCC and title resolution deadline. So these have effectively replaced our record title and off record title deadline, objection, and resolution deadlines. Okay, and so we talked a little bit about what UCC is, right? That's where liens against personal property are recorded, as opposed to public records, which is where liens against real property get recorded. And so it is important to make sure that our clients understand that the title company is performing a thorough search, right? And so how long does that take? I mean, I would just make it probably 10 days, 10 days from MEC. Should be plenty of time for title to go do that search if the buyer wants to do their own searches, right? What I would say is, as a real estate broker, I would not be the one performing that search myself, right? It's no different than a title search. I don't go and do a title search through public records for my client. I certainly am not going to take on the liability of doing the UCC search for my client of a manufactured home, right? Let title do it, let the client do it, have them talk to an attorney to do it. Whoever is going to do it, it's not you. Okay. And then again, when when all of that information comes back from title or whoever, I'm also not interpreting it. I'm not telling the buyer, hey, yep, there's no liens against this property. We're good to go. Right? Because the minute you say that, there's going to be one that didn't pop up on the search. Right? Now your client has a notice that, hey, you owe $40,000 because the property transferred and this lien was not paid off. Okay. So make sure that you're not the one who is interpreting those things, but it is important to advise our client as to what it is, the fact that it is important, and the fact that they should take it seriously and have somebody performing that UCC search who is familiar with doing it. Okay. And then these deadlines operate like anything else. There is a deadline by which we need to have that UCC search done. There is a deadline by which the buyer would have the right to object to anything in that UCC or title search. And then there's a resolution deadline. So it's no different than any of our other objection resolution stuff. Okay. These deadlines are all new. Lot lease and lot owner. So the lease delivery deadline, again, the seller is agreeing to provide that lot lease to the buyer. So when is that going to happen? We talked about the lot owner approval. When is that going to happen? And the lease review termination, how long does the buyer have to object to those things if either one of those are unsatisfactory? Okay. As far as seller's disclosures, no difference between your typical contract to buy and sell in this contract. New loan application and new loan termination deadlines, again, similar to our contract to buy and sell. What you'll see is that some of the assumption, right, and those other financing deadlines are removed from this particular contract, because I don't know of any lenders out there who are doing assumable loans on a manufactured home. Right? It's just not a thing in most cases.
Jessica,
Yep.
Does anybody have any advice on timeline for lot owner approval? How long they typically take to do that?
3 days.
A few days.
Yep, 3 days typically.
So
Okay.
7
Yeah.
days, safe 7 days then? Okay.
Yeah, I was going to say, I typically would pad it a couple days just in case there's a weekend or a holiday or,
Well, with COVID, I had one that took 14 days this year.
Yeah.
I had another one that took 20 days.
Wow.
Is the problem. And it's because they have Sun Communities has been really crazy. And Sun Communities owns the one in Evans and then the one in Frederick.
Mhm.
They've just been really difficult. And so I would say 14 days. I would give yourself some pad there, because that's what kills the deal right there. And
yeah. So
can't go in to their offices.
yeah,
Heather,
so
does it make
certainly
sense?
you could do something longer too. And that being said, if the parties are just going to agree, hey, we thought 7 and it turns out it's going to take longer, we're going to need to do an extension. As long as the parties agree, that's fine. Where you might run into problems, right, is what happens if you have the buyer and you're under contract for $40,000 and lo and behold, we're up against this deadline. We haven't seen anything yet, right? And now we have to get the seller's signature on an amend extend to push that out. And in the meantime, some other buyer has come in with a $50,000 offer, right? You think the seller's going to have any motive to sign your amend extend? I mean, you could get hosed in that case. Now your buyers have to go find something else. So, totally okay to push it out. It's not a bad idea either to have it shorter. It's just a matter that you need to understand how that could impact your deal. And who am I representing? Do I have the buyer? Do I have the seller? Right? If I have the seller and I don't deliver these documents in time and I deliver them late, then I could open up this 10-day period where I've basically given the buyer a free right to object. Right? So, you just need to know it's not necessarily right or wrong. It's just, how is it going to affect my deal if I have a short deadline and we need to extend, but I can't get the seller's signature, versus I have a long deadline, right? Which might give the buyer, you know, a lengthier time to terminate the contract than you might really want to give them, right? I might not want to give them 21 days. I might only want to give them 7 days if I'm fairly confident that I can get that lot owner approval. So there's pros and cons of both. You just need to understand how it's going to impact your deal based on which party are you representing.
Can I ask Heather one more question?
Yeah.
Heather, is Sun Communities an online application or is it in person? And do you think it makes sense to put it in the broker comments when you're selling, just to have them already have a link to apply if they're going to write an offer?
No, because it doesn't, because I think it depends on the community, whether it's going to be in person or online. But the problem that we ran into with the 2 deals that I've done is, or this last year, was that you have to do a background check and you have to do a financial background check, and then they have to do the lot approval. Since there was 3 different parties that were doing the approval, that's where it just became really long. But really, honestly, it's not worth anybody's time to do the application before getting accepted, because there is a cost to it. And with the buyers, most of the time they are, you know, short on money anyway in that price point.
Yeah. And, you know, it's one of those things where you might, I mean, if a buyer wants to be competitive and you really think it's going to be a competitive situation, it might make sense to throw the money at it. But like Heather said, most of these people that are buying these homes just don't have extra money to throw at things that they really can't afford to do. So, you know, I don't know. Is it possible? Yeah. Is it feasible? Probably not. Okay. Let's see, property or seller's disclosures. Again, seller's property and lead-based paint disclosure. If there's a deadline in the seller's property disclosure, the seller needs to provide the most current version of the seller's property disclosure. There is no separate manufactured home property disclosure. So just the standard property disclosure. There might be some pieces that don't apply to a manufactured home, and there might also be some stuff in there that, you know, that property disclosure has not been revised to reflect, that might need to be added, right, with respect to a manufactured home. If you know that there's a problem with the wheels or the axles or the tongue or whatever it is, well, that still needs to get disclosed if it's an adverse material fact, right? So property disclosure, we're just using the same one. Lead-based paint disclosure, again, still using it, same one, right? Loan application we talked about, seller private financing deadlines. Yep, go ahead.
On the lead-based paint, is it the same rules as if it's a regular house?
Yep, yeah, so nothing changes as far as the operation of that goes. Now keep in mind that in 2019, the whole lead-based paint, the operation of the lead-based paint section did change. It used to be that if it wasn't fully executed by all parties and properly filled out, that the deal was void. That is no longer the case. But as far as the form itself goes, it's still the same as the you know, typical contract to buy and sell residential, operates the same exact way. Okay. Seller and private financing. I mean, you will run into this maybe more frequently on manufactured homes than you will on a stick-built house, just because it can be difficult to get financing on some of these things. So there are some sellers who say, yeah, I don't mind financing the deal for you. And so if that's the case, that's okay. You're not going to hammer out the details as far as, you know, the 5/1 arm with a balloon payment, right? And here's the interest rate, here's the monthly bid. You're not hammering out those details in this contract. And we'll talk about that when we get to that section, okay? Appraisal deadline, appraisal objection, appraisal resolution deadline. Again, if somebody is paying cash, hey, guys, mute yourself if you don't mind. I can hear feedback coming from somebody. So these are going to operate similar to the appraisal deadlines in our contract. That being said, probably a higher percentage of people are paying cash for a mobile home or a manufactured home than they would for a stick-built property, right? So these may or may not apply. Even if they are paying cash, theoretically, they could still get an appraisal done, but part of the allure for a cash deal, right, is typically no financing, no appraisal, whatever. Inspection, objection, termination, resolution. Again, operate similar to, you know, the contract to buy and sell residential. Home insurance termination deadline, it's not the property insurance termination deadline, it is just the home insurance. So that makes sense, right? But otherwise it operates in a similar capacity. Due diligence documents, similar. Conditional sale, similar. Lead-based paint termination, similar. Closing date, possession date, all that other stuff, the same. Okay. So let's look at the terms real quick. The applicability terms, you guys know these things, nothing changes with respect to the applicability of the terms. Purchase price, right? You guys are, you know, familiar with this. This really doesn't look any different. You've still got the purchase price here. So let's say $50,000 is what you're agreeing to. That means this bottom line should be 50. This bottom line should be 50. Maybe your earnest money is 500, right? And maybe there's no new loan, it's just cash. So then 49,500 would go here, right? Or if there's a new loan, right? Maybe it's $500 earnest money, a $40,000 loan, which leaves 9,500 cash at closing to balance everything out. Okay, those are all similar. Seller concessions. The verbiage is a little bit different here, but conceptually it's all the same, right? The seller's still going to attribute X amount towards the buyer's closing costs. You know, whatever concession there is going to be included on the settlement statement at closing, right? So just be careful. One thing I will say, just because we're on this section, is that any amount that is listed here is in addition to any sum that the seller has agreed to elsewhere in the contract. So be careful, because I saw a contract come through the other day that had like a $5,000 seller concession here. And then in additional provisions, it said, at closing, seller agrees to credit buyer $5,000 towards the buyer's closing costs and prepaid. Well, effectively what that means is it's $10,000. So don't fall into that trap. That's on any of these contracts, not just this one. Just bring it up because it was the recent example. Okay? Earnest money, again, very similar here. It's going to be in whatever form, a check, a wire transfer, good funds, going to be paid and held by title company in most cases. Well, we're not going to hold it as Keller Williams because we don't hold earnest money. So probably the title company is going to hold it. Okay, all that stuff is going to be similar to the contract to buy and sell. Alternative earnest money deadline, similar to contract to buy and sell. Return of the earnest money, again, similar to the contract to buy and sell. If the buyer terminates and they have an actual right to terminate, buyer's entitled to a return of their earnest money, unless there, of course, is an earnest money dispute. Then the earnest money, if it's not already been returned following receipt of that notice to terminate, seller agrees to provide written mutual instructions within 3 days. So that doesn't change. That's the same as the contract to buy and sell. Okay. Good funds, similar to contract to buy and sell. So any proceeds for closing need to be in the form of good funds that will allow for title, fund the deal at closing. Okay. Time of payment and available funds. So again, similar to contract to buy and sell, either buyer does or does not have those funds that are immediately verifiable, and not less than that stated as cash at closing with capital C's. The fact that it's capitalized tells you it's a defined term, and it's defined right here, right? So if it's $50,000 and there's a $40,000 loan with that $500 security deposit or earnest money, cash at closing will be $9,500. That's your cash at closing. And that's what this section is referring to. Does buyer have $9,500 today? Okay. If they don't, then check the box that says do not. If they do, then check the box that says they do. New loan. So again, most of this is fairly similar. Like I said, some of the stuff that has been omitted is different just because it's not there, whereas it exists within the contract to buy and sell. So stuff regarding assumption is missing from this particular contract. The other piece that's a little bit different is we don't have the check boxes that say, conventional, FHA, VA, other, right? In this case, it just says buyer's going to be applying for whatever type of loan. So probably if it's a true manufactured mobile home, as you and I think of them, probably not going to be an FHA or VA loan, right? Probably conventional loan, portfolio loan, private money, hard money, right? whatever type of loan it is that they're going to be pursuing, then you would write that in there. Okay. Now, again, we talked a little bit about seller financing, and again, keep in mind, like, brokers get scared when they hear the term seller financing because they're not super comfortable understanding all of the terms associated with seller financing. That's okay. You don't need to be. If you actually read the text in here, all you're doing is you're just checking a box that says which party is going to deliver the proposed seller financing documents to the other party. And they're going to do that how many days before that seller private financing deadline. Those are the only things that you need to know. Which party is going to be responsible for drafting those documents and transferring them to the other party, and how many days prior to that seller private financing deadline is that going to be? Okay, so that being said, we have zero authority to draft seller financing documents. So I don't want you to take that on, and that is something that you should be uncomfortable with because you can't do it. Okay, they either need to go talk to an attorney or the parties need to figure it out themselves. But having the parties figure it out themselves is not a great idea, right? Go talk to an attorney, have an attorney draft some seller private financing documents, and then they've got the advice of an attorney, okay? If the seller is going to provide that seller financing, this contract is conditional upon the seller determining whether the buyer's financing is satisfactory in the terms of the seller's financing or private financing is satisfactory to the seller, including payments, rates, all that other stuff. Okay. Buyer also can terminate if the buyer is supposed to pay all or a portion of the purchase price with that seller private financing, then it's conditional upon them determining that it's satisfactory to them as well. And if it's not, then they have the right to terminate on or before the seller private financing deadline. If they don't, then they accept the terms. Okay. That's all similar. New loan application, again, all this stuff is similar. New loan review, all similar to the contract to buy and sell. There's some very minor differences, but for all intents and purposes, most of these things operate exactly the same as the contract buy and sell. Appraisal is the same way. Of course, it is conditional upon the buyer if they're getting a loan, right? And you've written in your appraisal deadlines, then they have the right to terminate if either they can't get the appraisal by the deadline, or if the appraisal comes in low, they can terminate, or they can do an appraisal objection, right? And then if they do object on or before that appraisal resolution, they need to have some kind of written agreement between them and the seller as to what's going to happen to that purchase price. Same thing with lender requirements. Again, it's not lender property requirements, it's lender home requirements, because the lender is not lending on the lot. The lender is only lending on the home. And so in most cases, the lender probably is not going to require repairs to the lot itself. I suppose it theoretically could be possible, but in most cases, they're concerned about the collateral, which is the home. Okay. So all that stuff operates similar to contract to buy and sell. Who's going to pay for the appraisal? Check the box, right? And then this is where we get into all the new stuff. So UCC search and title. So the seller is going to deliver to the buyer 5 days on or before 5 days prior to that UCC and title deadline, a true copy of the certificate of title for the home. So again, if we're talking about a deeded home, which has been purged, right, it has been permanently attached to the real property. It doesn't exist in like the DMV type records anymore. It exists in public records as part of the real property. Then don't use this contract, right? We're only using this for titled homes. So seller's going to provide that certificate of title showing that they are in fact the owner of the home or whatever other written evidence to the buyer. Now, I don't know that I would take other written evidence. I would ask specifically for that certificate of title, okay? And then the buyer's sole cost is advised to have that certificate of title for the home examined. So just because they gave you a certificate of title, is that current certificate of title or is it not? I don't know. Go check the UCC, right? Have an attorney look at it, have your title company advise you on it, but I don't want you as the brokers advising on that. That's beyond the scope of you as a real estate broker, okay?
So my question is how does this work for manufactured homes on a slab that have never been in the DMV. Can we get an O&E for it? Will public records be okay?
Well, if it's on a slab and it's never been in the DMV, it's either missing some records as a manufactured home, or it exists already as real property, right?
Right.
If it has a deed, then yeah, it's going to be associated with public records like you and I normally think of it, right? And we're going to use the contract to buy and sell residential. We're not even going to use this contract because it's not a titled home. It is a deeded home. Now,
Okay, so
there's-
I'm looking at the one I have listed in Sunflower,
yeah,
where it's a manufactured home and we had a deed transferred to it, but it's still a lot lease.
yeah. So there's, and I don't know, you may have jumped on a little bit late, but there's an exemption for this if the lot lease is longer than 10 years. So
Okay.
even though it may be a manufactured home that has not been permanently affixed, right? That's why it's the deeded home. It is not a titled home, and therefore you're not going to use this particular contract.
Okay, perfect.
Yep,
Sounds
you'll
good.
use
Thank you.
contract to buy and sell. Yep. Okay. Liens title resolution. Buyer has the right to obtain UCC search on or before that deadline. Make sure there's no liens or more outstanding mortgages or whatever other liens, water liens, sewer liens, anything else against the property. Or the inclusions, right, that are not identified in the contract. And then the buyer, in their sole subjective discretion, they can object to any liens or whatever. If they happen to find that there's something that, that is not satisfactory, wasn't disclosed, the seller isn't going to be paying off at closing. Okay. Obviously, if the buyer does object to any of that stuff, if the seller receives the buyer's written notice objecting to that stuff, which we're not already agreed to, then it operates similar to all of our other objection resolution type deadlines, right? If there is an objection, you have to have a written resolution by that UCC or title resolution deadline. And if there isn't, then the contract will terminate unless the buyer withdraws their objection. Okay. So even though this section is all new, it operates just the same as all of the other, inspection objection, termination resolution, appraisal objection, appraisal resolution, all those deadlines, they all operate in a similar fashion. Okay. Any questions on that piece? Property disclosure stuff. So again, if you have that property disclosure deadline, sellers agreeing to provide the most current version of the Colorado Real Estate Commission's property disclosure. Even if there is no property disclosure deadline, the seller cannot just waive their legal obligation to disclose adverse material facts of which they are aware. Okay. And filling out that property disclosure from the Real Estate Commission is probably their safest bet as far as how to avoid, right, getting in trouble for concealing adverse material facts. If you are diligent enough to take on, everything that's listed in the seller's property disclosure and you fill it out thoroughly, right, that's why that form exists, is to try to keep sellers from getting sued by buyers for failing to disclose. Okay. Disclosure of adverse material facts. So, seller must disclose any adverse material facts of which they're actually aware. If something happens to the property after the contract, they have to disclose that as well. And if they do, then the buyer would have a new right to object to that of 5 days, right? So again, similar to the contract to buy and sell, nothing really changes there. Property sold as is, where is, and with all faults, that's all the same. Right? Buyer has the right to do an inspection. So this is just a little bit different. Again, for all intents and purposes, same concept, but it says that they have the right to have the inspections of the home, right, as opposed to the property, the lot, which isn't mentioned in the contract to buy and sell, inclusions, leased items, and all those other things, right? So again, really the only change here is we've changed property to home, right? And now there's a discussion of the lot as well. But for all intents and purposes, guys, this is all similar. Nothing changes, okay? Inspection objections, we all know how those operate. Same thing with inspection termination. inspection resolution, right? If buyer objects, then we got to have a written resolution by the resolution deadline, or else the deal dies unless the buyer withdraws. Okay. Damage, liens, and indemnity. So again, for all intents and purposes, it's the same. We've just taken property out and we've said home and lot, right? But if the buyer damages the property, then they can't just terminate the contract and, you know, walk away. They're still obligated to fix whatever it was that they damaged. If they're workers, right, like the inspector obviously was hired by the buyer. If the inspector damages, technically the buyer's on the hook for it, right? Now, hopefully the inspector has, you know, insurance and whatever, but the contract is between the buyer and seller. Therefore, buyer is responsible if they break something as part of their inspection. Okay. Insurability. So again, we're not talking about the property insurance termination. We're talking about the home insurance termination. But again, operates the same, right? Buyer needs to go make sure that they can get satisfactory home insurance on the home that they're buying, and it's contingent upon them reviewing all that in their sole subjective discretion. Okay. Due diligence documents. So, you know, as far as due diligence documents go, right, in the contract to buy and sell residential, we have any leases are in 10.6.1.1, and then any other due diligence documents being requested are in 10.6.1.2, right? And here we're saying if the respective box is checked, the seller will deliver whatever copies of the documents pertaining to the home, the lot, and any leased items to the buyer on or before that due diligence documents delivery deadline. So 8.6.1.1 kind of becomes our for the occupancy. So any current leases, including any amendments or other occupancy agreements pertaining to the home, right? So this is like if I'm an investor and I'm purchasing a mobile home that has occupants living in the property, then that lease would go here. Certainly you could, you know, put the lot lease there, but the lot lease stuff is already addressed in a separate section, right? So you don't need to put that here as well. Doesn't hurt, but you don't need to, okay? Any leased items. So if any lease of personal property will be transferred to the buyer at closing. So this would be like your solar panels or whatever. All that stuff would go right there. Excuse me. And then 8.6.1.3 would be any of those other due diligence documents that you know, typically you see a broker request. I was talking to Harry yesterday about, you know, some of the documents that agents write into this section. You know, the manuals for the fridge, right? Like if your buyer is not ever theoretically going to object to those documents, then don't put them in here, right? I don't know, maybe your buyer theoretically could object to the owner's manual on the oven, right? If there was something in there they didn't like, but 99.99% of people are not going to object to any owner's manual related stuff. You don't need to ask for those things as due diligence documents. So just something to consider. If you don't need a contingency, there's no reason to write one into the contract. It makes your offer look worse, particularly in a competing situation, to have contingencies for things that you don't even need, that your buyer would never object to, okay? Let's see, due diligence documents, objection, review, resolution, right? All those things operate similar to standard contract to buy and sell. Conditional sale, if they have to sell a property in order to purchase this one, that's all going to be the same, right? Put the address there. Whoops. Where did I go here? Sorry about that. Source of potable water. Does the buyer acknowledge receipt of the source of water? Or do they not? Check the appropriate box. Okay, lead-based paint. Again, we already kind of talked about this. It operates exactly the same fashion as the contract to buy and sell. Carbon monoxide alarm. So if the home, right, not the property, if the home has a fuel-fired heater, appliance, fireplace, attached garage, or includes one or more rooms lawfully used for sleeping purposes, aka bedrooms, then the parties, you know, acknowledge that they have to be within 15 feet of the entrance to any bedroom. Okay, so really nothing changed there. Meth disclosure, obviously if the seller knows that meth was ever manufactured, processed, cooked, disposed of, or used or stored on the lot or the home, then they have to disclose that fact, unless of course it's been cleaned to state standards. What I will tell you is, if you've never heard my little spiel on meth, the law is very clear that the seller has no obligation to disclose if it's been cleaned to state standards. However, brokers do not have that same carve out in the law. Okay. And there's actually some lawsuits going on right now, and we'll see how the courts rule. But somebody sued a broker for failing to disclose that a property had previously been a meth lab that had been cleaned up. And effectively their argument is the sellers are protected under Colorado law from disclosing that. However, brokers are not, and brokers still have an obligation to disclose an adverse material fact. And so it will be interesting to see what the court rules, but at least for right now, as a broker, if you ever know that meth was used or stored or manufactured or whatever, you have to disclose, or else you're taking the risk of concealing a fairly significant adverse material fact. Okay. Questions on any of that stuff so far? Okay. Closing, again, fairly similar, looks a little bit different, but closing will be as designated by who. I typically like to just see one party in here, either buyer or the seller, because those are the parties to the contract. If you put mutual agreement in here, what happens if the parties don't mutually agree to a closing date or time? Just put one party in there. The closing will be conducted by who? The closing agent, as opposed to the title company, right? So maybe it is like Stewart Title, for instance, okay? But whoever's going to be the closing agent on the property, right? Whatever company is going to do it, that's where you would put it right here, okay? Closing documents and closing info, seller and buyer are going to agree to cooperate with the closing agent to make sure that the property can get closed. Buyer is obtaining a loan to purchase the home. Buyer acknowledges that the lender is required to provide closing agent with, all of the loan docs and financial info concerning their loan. Buyer and seller agree to cooperate with getting any of the documents necessary, right? All that stuff is fairly similar. Disclosure of settlement costs. Again, buyer is aware that there's different attorneys, lenders, inspectors, title companies, yada, yada. Refer them 3 if if you're going to refer anybody, okay? Payment of liens and encumbrances, unless it's been agreed to somewhere by the buyer and seller in writing. Any amounts that are owed on any liens or encumbrances against the property, those are all going to be paid at closing by the seller and come out of the seller's proceeds. Okay. Closing, again, fairly similar. Who's going to pay the closing services fee? Most cases it's half and half, doesn't have to be. Lot lease status letter. So this is a little bit different, similar to the HOA stuff, but instead of HOA, we're talking about the lot lease. So at least 14 days prior to closing, seller agrees to promptly request the lot owner deliver that status letter stating that 1, the lot lease is in full force and effect and there have been no subsequent modifications or amendments. 2, the amount of any advance rentals paid concessions given and deposits paid to the lot owner, if any. And 3, the amount of monthly lot rent paid to the lot owner. 4, that there is no default under the terms of the lot lease by the seller or the occupant. Okay, so similar concept to an HOA status letter. It's just regarding the lot lease and stuff. And then who's going to pay for it? Buyer, seller, half and half, someone else. Okay. Any ancillary fees or costs assessed by the lot owner have to be paid by who? Okay, so doesn't matter. There's no right or wrong. Pick whichever one. You can split them however you want to do it. That's fine. If there's a checkbox in the contract, it's okay to pick. Okay. As far as utility transfer fees, so utility transfer fees can change. Any fees that transfer utilities from the seller to the buyer must be paid by who? Sales and use tax is going to be paid by who? All that stuff is similar. I don't even know, Jerry or Heather, are there sales and use taxes stuff on manufactured homes?
I haven't seen one.
No. Okay. Jerry, you have any experience otherwise? Okay. Let me get back to the contract here. Assignment of leases. So Seller has to assign to buyer all the home leases in effect, right? That makes sense. If there's a lease in place, it's going to continue in place. And the buyer has to assume the seller's obligations under those leases. Seller has to transfer to buyer any leased items as well. That all makes sense. Prorations. So again, taxes will be based on typically probably the most recent mill levy, most recent valuation. If you're purchasing the property as an investment, how are the rents going to be prorated? Other prorations, water, sewer charges, propane, whatever else you're going to put there in most cases. Probably not a lot else that's going to be prorated with manufactured homes, just like we don't typically do a lot with, the standard contract either. Okay. Obviously, final settlement is all the same. Possession of the home, not the property, is going to be delivered to the buyer at the possession date and time. That all makes sense. If for whatever reason the seller fails to deliver possession as specified after closing, then the seller will be responsible for what amount per day, right? $100, 150, 250, 500, doesn't matter. But it's best to put something in there. I see people put 0, and that's just not a very safe thing to do. I always recommend putting something in there, okay? Is the buyer going to occupy the property as their principal residence, or are they not? It's all similar. Computation of days and deadlines is similar. Cause of loss and insurance, right? All of this stuff. These are all similar. Not going to go through all of that. All of this stuff, I think everything else is the same. Yeah. Entire agreement, all that stuff is the same. Yep. So nothing else is different in this contract. So for all intents and purposes, right, the big difference is property gets changed to home and lot, right? And so, but the way that the dates and deadlines work, they're all still similar. It's just that there's some new stuff regarding the UCC, regarding the lot lease, regarding the lot, the lot approval, the approval of the park, approving the buyer, right? Those are all new things, but otherwise the construction of the contract and the way that it operates, those are all the same, okay? So let's talk about, and again, keep in mind, that's really for a mobile home that's in a park type setting, okay? So we're gonna switch gears here, and now let's talk about a manufactured home that is being sold in conjunction with the land that that manufactured home sits on, okay? So in that case, what we're gonna do is we're not gonna use the manufactured home contract. We're actually gonna use the manufactured home addendum, okay? So what this manufactured home addendum says is, okay, this is an addendum to the contract to buy and sell real estate, and it's being made a part of which of these contracts? Either the contract to buy and sell real estate land or the contract to buy and sell real estate commercial. So why do we not see the residential contract in there?
Because if it's purged for the property, you're buying the property of the house, correct?
Yeah, if it's purged, we're just going to use the contract to buy and sell residential, which is going to cover all of the things that this contract covers anyway, and it wouldn't apply if it's purged, certain aspects of this wouldn't apply if it's purged regardless, right? So in this case, what it's saying is there might be some instances where the land contract makes the most sense to fill out as the contract to buy and sell. So if it's a 40-acre property, let's say, there might be some pieces of the land contract that are important to our transaction. However, the land contract does not deal with some things that need to be added into the land contract that typically relate to a manufactured home. And so what we would do is we would fill out the contract to buy and sell real estate land, and then we would take this addendum and we would add that to the contract to buy and sell land. The other potential option is, in some cases, you might have a commercial type property, and maybe there's like an on-site mobile home or manufactured home, a trailer, right? And so what you're doing is you're saying, okay, we're going to sell the commercial property, and we're also going to transfer that manufactured home that's on site. We're going to transfer that with the property as well, but the commercial contract doesn't address certain pieces that our manufactured home contract does. And so we're going to take those pieces of the manufactured home contract and incorporate them into this commercial contract. Does that make sense to everybody? What the different possibilities are, which contract to use in which setting, right? If it's a mobile home manufactured home park, we're going to actually use the manufactured home contract. If it's a piece of land with a property that is not purged, that is manufactured home, right, we'll probably use the land contract in conjunction with the manufactured home addendum. And if it's a commercial contract, mainly a commercial type property, we want the pieces of the commercial contract, but we're going to have to add these pieces from the manufactured home contract, and we're going to do that with this addendum.
A little outside the box, Jesse, but just spitballing here. What about these storage container homes? Does that fall kind of in this? Because you do land and a personal property, or land and then this agreement?
Well, so again, you have to consider, is it a storage container home that is on real property, and is that real property being sold, right? If it is, then we would use probably the land contract with this manufactured home addendum, because it's not the container home is probably not a deeded home. It is probably a titled home, right? Or maybe even a bill of sale. Maybe it even gets transferred with a bill of sale, right? So you can do that, assuming there's a real property component. And if that is the case, assuming it is not somehow a purged, container home, or if it is not considered part of the real property, then what you're going to do is you're going to use the land contract in conjunction with a manufactured home addendum, even though it's not necessarily a manufactured home as you and I think of it, right? That makes sense?
Yeah, that was perfect. Thank you.
Okay. Oh, again, it's going to be added to which of the following contracts that are dated, whatever date, the known as street address. This addendum controls in any conflict with either the land contract or the commercial contract, right? The purpose is that the property contains a manufactured home, but those particular contracts don't contain these provisions that are specific to manufactured homes. So this all should look familiar, right? We've got the manufacturer, model, serial number, all those things, okay? What we don't have is we don't have a lot number, because we're not talking about a lot number in this case. It's not in a mobile home park, right? It's on a piece of land, or it's included with a commercial property. Okay, so inclusions. So again, we list some inclusions that are common in residential transactions that would not be there in a land transaction or in a commercial transaction. So this is all similar to the manufactured home contract to buy and sell. Similar with the inclusions that are not attached. Again, we kind of went over the fact that skirting, wheels, tongue, access equipment, such as the ramp, deck, and stairs and whatever, right? Those are specific to the manufactured home contract. And so we need to add those into the other inclusions that are not attached, that are standard in just the residential contract. Okay. Inclusion conveyance, again, they're going to be transferred free and clear of any liens and encumbrances. Any other inclusions, right? Again, this is where you're going to insert washer, dryer, dishwasher, fridge, oven, microwave, whatever. Okay. This looks a little bit different, because the only dates and deadlines that we need that are not associated already with the land contract or the commercial contract are these UCC and title deadlines. So we've just taken that out of the manufactured home contract, and we popped it into this addendum, and we've said, okay, we're going to add this to that. Okay. Type of loan, what type of loan is the buyer going to get? And then most of the rest of this is all stuff that has just been pulled. If you notice, it doesn't go in perfect order, right? Section 1, 2, 3, there 4, and then 7, right? So all we've done is we've taken sections out of that manufactured home contract, and we've just put them in this addendum. So the verbiage itself is not terribly different. And then you'll see section 8 and 9, right? Those are gone because they're already addressed in the land and commercial contract, okay? And then there's stuff like the inspection, right? Where we're not even taking all of section 10 and adding it to it, because section 10 in those other contracts exists, right? And all we're doing is we're saying the provisions of the inspection are also applicable to the home. Okay. So nothing else in this addendum is a surprise or anything that we didn't go over in the manufactured home contract. And most of this isn't even new compared to the residential contract. And it's just, you need to know when to use which form. And am I talking about a home that's in a park, or am I talking about a home that's on a piece of land, or maybe a commercial deal that includes a manufactured home or an on-site trailer type thing, right? But everything else is the same here, okay? It's either the same or it's been omitted from the addendum because it already exists within the body of the land contract or the commercial contract itself, okay? That makes sense to everybody? Just have questions on the addendum and when it's appropriate to use the addendum? Okay. So real quick, and these are going to go fast, guys. The manufactured home contract amend extend. So if you've written a contract deal, you know, on a manufactured home contract, then this is the amend extend that you would use. You would use this, and it again, the only reason we do that is because it references the home as opposed to the property. So what is getting amended, right? It has all of your deadlines there, just like the contract. And then again, similar construction to the normal amend extend for the typical residential contract, right? Any other dates or deadlines that need to be changed, any additional amendments, right? Then you've got your acceptance deadline, buyer and seller names, okay? So that one's pretty straightforward. Stop this, get to the counter. So the counter proposal, again, looks very similar to our typical counter proposal. It's just that it omits the word property and replaces it with home, right? So still looks similar otherwise. We have the known as street address, buyer and seller names. This is a counter proposal that amends whatever the contract date was, right? All of your manufactured home dates and deadlines as opposed to your standard residential deadlines, right? First, purchase price and terms, are you going to counter the purchase price, right? Whatever attachments, any other changes, okay? So nothing else, again, it operates similar to any other counter proposal that you guys have seen before, but again, I guess the big takeaway that you guys need to know is which contract am I supposed to use in which circumstance, and which transactions am I not allowed to participate in. Okay, so I don't know. You guys tell me what type of transaction can you not participate in?
One that does not involve.
Yeah, you cut out there a little bit at the end, but I think you were going for one that does not involve a real property component, right? So it either has to have sale of the land or a lease of the lot. If it is strictly a sale of the manufactured home itself, no real property component, that is not covered under license law, that is not covered under our errors and omissions. Those types of sales, you would have to register with the Division of Housing to do those. And even if you took the initiative to go register with the Division of Housing, no, you are still not allowed to do that under Keller Williams. So I don't want your name associated with those types of transactions. That's not run through the office, okay? So if someone calls you up and they say, hey, Ann, I've got a property, and I'm not picking on Ann for the answer. Anyone can pipe up. I'm just using her name. Hey, Ann, I've got a property. I own a 2.5 acre lot, and I've got this manufactured home on there. Still has the wheels and everything on it, right? And we just need to sell the whole thing, right? A, are you allowed to do it? Yes. And B, which contract would you use in that case?
The manufactured home.
Which manufactured home? Are you using the manufactured home contract, or are you using the land contract with the manufactured home addendum?
The second one.
Yeah, the second one, right? You're going to use the land contract with the manufactured home addendum, because keep in mind that manufactured home that manufactured home contract is when there is only a lot lease, not a sale of the land, right? Someone calls you up and says, hey, Danielle, I've got a mobile home in Cloverleaf I'd like you to sell. Are you allowed to do that transaction? Yes, right? And which contract are you going to use?
It's just the mobile home with the lease
Yep.
of
in
the
a
land.
mobile park.
What was that?
Yeah.
Sorry.
Yeah, in a mobile home park where the lot is being leased from the mobile home park.
Yes, we can do it with the, oh my gosh.
The manufactured home contract, right?
Yeah, the manufactured home contract.
Yep. So
Jesse,
because
what if they were just selling the mobile home and they expected it to get moved out of the park?
Yep. So if that's the case, you're not negotiating a lot lease in that case. So are you allowed to partake in that transaction?
I'm thinking no. Okay.
Correct. You are not allowed to participate in that type of a transaction. Okay. So a couple questions that have come up. People say, okay, well, I'm getting ready to list a mobile home in a park or a manufactured home that's on a piece of land, right, that is being sold in conjunction with the manufactured home, even though the manufactured home is a titled home, it has not been purged, right? I'm getting ready to list it. Which listing contract should I use? What do you guys think?
The land with the amendment.
So you're talking about contract to buy and sell, right? If I'm listing it and I'm talking about my exclusive right, there is only one exclusive right to sell.
Right.
There is no separate exclusive right to sell for specifically manufactured homes. Now, there's two ways the Real Estate Commission could go with this, right? For now, effectively, what we have been advised to do is you just use the regular exclusive right to sell, okay? Now, there are some terms that are used in there that really are not 100% appropriate for the particular transaction you might be partaking in, right? And so the Real Estate Commission may choose to have a separate exclusive right to sell for manufactured homes, or they may choose to amend the existing exclusive right to sell to just add a phrase that basically says anywhere that the term property is used, it's going to refer to either the property or the home and the lot, right? So I'm hoping that's the case. I'm hoping we don't have a new exclusive right to sell just for a manufactured homes, right? Hopefully it's just they add a little blurb in there that says property is going to also refer to home and lot. I don't know. Attorneys need their jobs, and so they might create a new form for it. I don't know. We'll see what happens. So, but for now, we've been advised to just continue using the exclusive right to sell that we've always used. Okay. How about property disclosure, source of water, lead-based paint, square footage disclosure? Are those still required? And if so, is there special forms for those?
Yes, required, no special forms.
Yep. Just doing the same old thing that we've always done as far as all that stuff. Yes, you still need to disclose the source of water. Yes, you still need to disclose where you got the square footage from. Yes, the seller still has an obligation to disclose adverse material facts. All of those things, right? Nothing changes there. The one weird piece that we really haven't been given any guidance on is closing instructions, right? Is the title company going to perform it for the same dollar amount that they do, on a residential deal? What's going to happen there? That one, I don't know. I would assume that title will probably still sign closing instructions, but Heather, Jerry, you guys still doing closing instructions on your manufactured homes?
Yes. And
Yeah.
the title company usually has their own form, or what they do is they'll use the regular forms, but they cross out like most of it.
Yeah.
So.
Yeah. Because there's pieces in there that aren't going to apply, right?
Right. Mm-hmm.
So I don't know, Heather, do you have a different experience or similar?
Yeah, so in Frederick, and I think it's the same in Sunflower up in Fort Collins,
Right.
they allow the same closing instructions. It's just the same.
Yeah.
For the other one, it depends on the title company that you use. And I'm not sure Stewart Title has a has a direction on the new this year. So
Okay.
Yeah.
I don't know. What other questions do you guys have?
Hey, Jesse, it's Janelle.
Hey.
Hi. So you said once it's purged, it technically can't be moved anymore. It's like essentially taking a license plate off a vehicle, right?
Kind of. I mean, because what purging really refers to purging it from the, like the DMV's records,
Right.
taking it from a titled property to a deeded property so that there is no title anymore. That's really, purging doesn't refer to the attachment itself. It refers to the records process.
Sure.
Purging those records. But yeah, I don't know.
So the question, I guess, is, so once you've purged it, if it can't be moved, it essentially has to stay with that property, the physical location, until it's destroyed?
Well, so there is a whole process of destroying a manufactured home, and that's one of the things that I can provide you a link to, but the county does actually have forms that are like the destruction of a manufactured home. I didn't actually go look at the form, but I know that it exists because of these resource documents that I was looking at. So that being said, again, keep in mind that purge not only refers to the records, but it means that that property can no longer be, effectively moved across public roadways is what.
Right.
So yeah, I mean, maybe you could move it on your own property somewhere, but you're not allowed to take it and move it along the roadway.
I have a question on that. I thought purged meant that there's a permanent foundation, that now the structure has no axles or wheels. So that way, that's the reason why it can't move.
Well, right. So permanently attached, that's what I'm referring to when I say permanently attached. However, there are cases, again, keep in mind that like with the 10, if it's a lot lease that's over 10 years, right? They've effectively said, we're going to consider that a purged property, because if it's there for more than 10 years, it's not going to move, right? So there are some weird exceptions that may or may not happen with regards to a 10+ year lease. But in most cases, yes, the way that you get a property purged is to attach it permanently to a foundation. You remove those axles and everything else, but the 10-year lot lease is like 10+ year lot lease happens to be the exception that they've carved out. And then theoretically that gets treated like a purged property.
So Jesse, if you have a property that has a manufactured home on it, and now they want to get rid of the manufactured home and build a stick-built house, I, as a broker, could not sell that manufactured home, correct?
Correct.
Okay, all right. Okay.
Yep. Okay, that's all I got, unless you guys have other questions. Sorry you had to endure that. It was painful, but.
It's funny.
Okay. Well, have a good day. If you guys have questions, you know how to get a hold of me.
Thank you.
Thanks.
Okay. Yeah. See you guys.
Jesse.
Thank you.